Hello everyone, myself Monisha and I'm legal intern at LEXIS and Company. Today I'm here to talk to you about the most important case and you can say most important judgment given by the Supreme Court, that is case law of Mangala Wamen Karandikar versus Prakash Damodar Rande 2021. So Supreme Court gave the landmark judgment on this case and considered that provision to section 92 and 95 of Indian Evidence Act applicable only when terms of the document leave the question in the doubt. So we will discuss the fact of this case is basically what happened. Mangala Wamen, who was appellant, and her husband established business of stationery named Karandikar Brothers before her husband dismissed in 1962. So appellant decided to run the business by herself till 1963. She did that too. After some times, she was unable to run the business. So she decided to give the business to the respondent for the certain period of time and entered into an agreement on 7 to 1963 and signed the same. In 1980s, the appellant wanted to run the business again, and regarding the same, she issued the notice on 2012-1980 to the respondent to vacate the suit premises on 31st/01/1981. Respondents say that she did not hand over the business to him. Instead of that, this business was given on rent by making the agreement of rent without any ambiguity. After hearing all this in 1981, the appellant filed for civil suit in District Court, Pune. After that, the trial court gave judgment in favor of the appellant and held that the agreement was to create a sale of business and ordered the respondent to hand over the sued property to appellant. Respondent was disagreed by this and respondent took this case to higher judiciary and made appeal against the judgment of the district court, where in this case High Court gave judgment in favor of respondent considering the section 95 of Indian Evidence Act, and Bombay High Court held that respondent entered into a license agreement under section 15A of the Bombay Rent Act. After this judgment, appellant appealed in the Supreme Court because she disagreed to the judgment of High Court, where in this case Supreme Court observed some facts that it is clear from the reading the contract that the parties had intended to transfer business from appellant to respondent during the contractual period. So this was means for a specific period of time there was contractual agreement. This agreement was not meant as a lease or license for the respondent to conduct business. However, the respondent contends that the meaning of the document should not be cut solely with reference to the language used in document. Rather, extrinsic evidence need to be utilized before abusing proper meaning to the contract. As per section 92 and 95 of the Indian Evidence Act, only in case where the terms of the document cause a doubt will one resort to the proviso. In case where it is simple and clear, the provision would not apply. After that, we will talk about the section 95 of the Indian Evidence Act. What does it talk about? When a language used in a document is plain in itself but is unmeaning in reference to the existing fact of the cases, evidence may be given to show that it was used in a peculiar sense. So, Supreme Court held in this case and gave the judgment that use of extrinsic evidence take can be taken only when the terms of the document leaves the question in doubt. But when the document is straightforward and present no difficulty in constructing it, then the proviso does not apply. In this regard, we may say that Section 95 is built only the proviso 6 of Section 292. So, this judgment was given on the relying on the case of Rohitas Kumar versus Om Prakash Sharma 2013. The court held that if the interpretation of the High Court is taken, then there would violate the basic tenet of legal interpretation and enlarge the scope of proviso beyond section. Further, it was held that Section 92 explicitly prohibit any oral evidence which would contradict every add to or subtract the terms. It also went to the hold that the ambit of Section 95 is not appreciated by the High Court, by which the court only appreciated the evidence which amount to the breach of contract and not the ambiguous language of the contract. I hope you have understood this case. And for more such information and for more such topics, do not forget to subscribe to our channel. Please do share, like, and comment. Thank you.